period.
Period from where he is entitled.
No, in the intervening period, was he superseded by any other officer?
Superseded.
Have you made them parties?
Not here, my lord. As of now, they have not.
Then how can
Our claim is that, my lord, we have made the party who has superseded from the rank of 2IC, my lord. We have made all those parties, my lord. So he wanted that his juniors, from the date when he was promoted, the petitioner should also be entitled.
no? But
Lordship,
if they are not parties, then
They are party, my lord.
are they are they
The
appearing here?
notices has been served upon them, and they have even also given that they don't have any objections, my lord.
Is that so?
It is on the record, my lord.
If matters are proceeded ex parte against them, then if they
My
have
lord, it's
no
already on the
grievance,
record.
then of course.
Already on the record.
Lordship, we cannot produce it to the petitioner, Your Lordship, as we got the instruction from the department, Your Lordship.
Pardon?
We cannot produce it to the petitioner, Your Lordship. DPC proceeding, Your Lordship.
No, you see. Yes, you can do. You have to produce it to the court. I'm not talking to the petitioner. The court will have a look at it. If whatever is entitled to by the petitioner, that you have to give. If there are certain confidential matter which could not be, then naturally that's is understood. So it's incumbent upon you to. I think that was the instruction also that you have to sort out. I think I had made it very clear the last time around. You have to sort out what is relevant to be
Documents
produced
were-
or copied for copy to be given to the petitioner and what are.
My lord, 26 July order is quite clear, my lord. They said that the copies are ready. Due to my absence, they could not give
Yes,
me.
yes, yes. So perhaps the whole complete fine may not be
lord, definitely.
required. Only what is.
What was the finding of the DPC, my lord? Quite reasons.
Anyway, if the file is produced before the court and the court will examine it, then the matter can be, the court will have to take a decision.
My lord,
Not
that's
not necessarily for you to.
my lord, for the proper assistance, what were the reasons for the DPC to deny the promotion, my lord?
How long?
1 week, Your Lordship.
On pre-meet by the respondent, seeking adjournment, the same not being objected to by the petitioner. Matters adjourned. This is the same after 2 weeks.
Highly
It should give you
obliged.
enough time. No more adjournment.
Highly obliged, Your Lordship.
Excuse me.
I will please, Your Lordship. Lordship, I pray for item number 13, Your Lordship. I beg to make a mention for item number 13. Your Lordship, I braved for 3 weeks' time, Your Lordship.
Why?
No objection.
Nobody is interested.
Lordship, due to the non-availability of conducting counsel, Your Lordship.
This is for enhancement of
It's
compensation.
about, yes, Your Lordship, land acquisition.
Have you received the compensation?
No, Your Lordship, no, we have not received a whole amount.
It was not given to you
Yes, Your Lordship.
on pre-meet by the appellant, seeking adjournment on the ground that the of the learned senior counsel who is conducting the matter not being able to appear before the court today. The same not be objected to by the respondents. That is adjourned. This is the same of the 3 weeks.
Oblige, Your Lordship.
Please, Your Lordship. I beg to make a mention of item number 12, Your Lordship. If this matter may be taken up after 2 weeks.
What is this matter about?
This is with regard to suspension from service, Your Lordship.
On pre-meet by the petitioner, this is matter of the 3 weeks.
Oblige.
Highly obliged.
Please, Your Lordship, I beg to mention item number 11, Your Lordship. I humbly pray 2 weeks' times may be given, Your Lordship, for the written argument.
Your Lordship, here I am for the petitioner. That argument had been heard at length, Your Lordship, only for filing the written argument. I have already filed it, or they have given twice time for filing the written
2
argument.
weeks time, Your Lordship.
The records have been called for.
Yes, this is not. This is a service matter.
Okay, not required.
Not required. Not required.
Oh, I thought, see,
No, this is not Akang matter. This is service matter.
the moment I see Yarrow Hills means all acting
Yes,
matters.
yes. The hearing has been done at length. It's over. But only as there is
We
order
need
for.
to file the written argument, Your Lordship, and some authority also we need to enclose, Your Lordship.
Why is taking you so long? You just have to devote some time,
Yes,
go through it. You can do it.
Yes, Your
Why
Lordship.
would you wait for your senior to do it?
No, I'm searching for the authorities also, Your Lordship, to enclose, so need some more time, Your Lordship.
If you're still searching for authorities, mean you are on a weak wicket.
This is the third time after after final argument.
Please do it.
Yes, Your Lordship.
1 week?
Lordship,
weeks-
1 week,
2
my
weeks,
lord,
Your
because
Lordship.
this is just
2 weeks, Your
lingering
Lordship, I
because
humbly
since
pray,
from
Your Lordship.
2018, my lord, actually somewhere 21, but the hearing is already done, concluded.
Now I've forgotten whatever you have submitted also. On pre-made by the respondent. GHCDC.
Yes, Your Lordship, 1 to 3.
Seeking some more time to file the written argument. The same not be objected to by the petitioner. Matters adjourned. Oh, this is on the ground of that agitation.
Yes, Your
No,
Lordship.
no, yes, that for non-compliance of the COVID-19 the protocol, that is the allegation against me.
Yes,
That is yes.
there was some,
Yes, there was
confusion,
some yes non-compliance of the COVID-19, but there were 8 of them. 8 of them were suspended. Only myself was terminated. Others are reinstated. I have put it in my rejoinder also. It is there.
Anyway, we'll look at it.
Yes, Lordship.
Yes.
Authorised, Lordship.
Daily list item number 1.
Your Lordship, in this matter, they have not yet complied to the second part. The status they have complied, but with regard to payment of areas, it seems it's still under preparation. That's my instructions.
So the intention is there.
Maybe.
So, Your Lordship, there is
Until and
no question of
unless it has
intention,
not-
Your Lordship. Your Lordship already orders is passed and government is sanctioned.
It's only
everything
on
is done.
paper,
So,
Lordship, till
it's only
date.
paper. So, Your Lordship, this content may be
See,
closed.
Mr. Devrat, that could be, but if again, see, just as I was observing just now, if you have the intention to do it, you do it. We can understand paperwork might take some time, but if the intention is there, it is incumbent upon you, rather it is incumbent upon the department to process the matter expeditiously.
Yes.
If you delay, then you see, it can be construed as an attempt to,
Violate.
to deny the rights of the petitioners, in spite of the fact that you have, agreed to comply with this order. Of course, 1 week, 2 weeks time may be given to you, but then you see, you
No,
cannot
Your
just
Lordship,
go on like this.
Lordship, this is a matter. So many people is there. They are in several places,
can
and
understand
then
that.
all this,
You can understand.
all the service record and that to be, and then
Preparation has to be
ultimately-
from the head office only, where all the records are there.
How many personnels are involved here?
191.
Not so many. What is 191 compared? At the
In the
all-
earlier round,
all India level.
2,339 people were granted the benefit.
this here no denial, Your Lordship. That's the order when it's come. out,
Lordship,
it is
that it
clear.
come after 2 or 3 weeks. Let them.
Okay, I'll not pass any
Lordship.
order on your submission as far as the first part, second part
Yeah,
not
Your
being
Lordship.
complied with. We'll wait
grant
for
them
the
time.
complete order, rather the
Complete compliance.
Complete compliance. 3 weeks then, and no more. Otherwise, another contempt will follow.
Your Lordship, it will be difficult to give
Why?
a specific time, Your Lordship, because it is most important is here, Your Lordship, they have to compile this.
Then I'll give you 3 weeks time. If you fail to do it, you can come with any excuse, fine. Number one, I may impose costs on you. Number two, we might draw another set of contempt proceedings. And contempt, you know very well, it's not by the parties, it's between the court and the party.
After 3 weeks, they should satisfy that they have done something, Lordship.
4 weeks time I'll give you.
Lordship.
What is the progress I can give only this much? What is the progress of it? Regarding the progress of the matters I can give, but
Compliance, complete compliance. Till they receive the money in their pocket. Till that time.
If he has received, I'll produce before this court that we have received something.
Please do.
Obliged.
Mr. Ardemna, CGC has commented that the process may take some time since the department has to deal with a number of personnel or rather the petitioners are concerned. As such, it is prayed that some more time may be allowed for the complete process to be completed, for the complete process to be finalized. Mr. P. Nongri, Learned Counsel for the petitioner, has submitted that it is incumbent upon the department to comply with the direction of the court, though it is not expected that the same be completed in a short span of time, perhaps in a day or two or a week or so. However, considering the time taken by the department to settle the matter, the Learned Counsel would submit that even if the court allows some latitude in this matter, direction may be given for the respondent or department to comply with the order in its entirety. On consideration of the sufficient merit, the court would allow the process to be continued. However, it is expected that the department should make serious effort in this regard, and the process to be completed expeditiously. Accordingly, as prayed for, 6 weeks time is allowed, and no further adjournment, no further accommodation will be given to the respondent thereafter. 6 weeks.
Obliged.
This is item number 7.
Item 7, it's a miscase which they have filed for extension. In fact, that miscase can be closed, Lordship.
That can be closed then.
It can be closed because they filed for extension because
You file this case for what?
It was
they have
for
filed for
extension.
extension
So
because the matter is pending for Supreme Court. The Supreme Court, it's over now.
Then doesn't survive anymore.
So elusive, let it be together elusive.
Appearance.
Why?
This 7 may be together because if it is disposed of, then again problem will come.
7 is
No
practically,
problem.
This was I seek extension of time elusive.
7 is practically a dead horse. You see, even if this court has given extension or not, you have approached the Supreme Court and matter has been disposed of.
Dismiss.
Now we are only on this, on the process of completion. So, anyway, this is matter after 6 weeks.
Item number 2.
Obliged.
May it please your Lordship. Lordship, all pleadings have completed, your Lordship. Lordship. We proceed for hearing.
Yes.
Items 2, 3, 4, 5, 6, Lordship.
Respondents? Some of you doesn't look very sure whether you have done it or not. Learned Counsel for the petitioner has submitted that pleadings in this case is complete and has prayed that this matter may be heard. Accordingly, this is matter for hearing after 2 weeks.
Much obliged, Lordship.
Same order, Lordship. Item 2 to 6.
Same one.
Obliged.
I'll come back after.
Lordship.
Supplementary list item.
My lord, I'm praying for lots of interest. My lord, hearing item number 8 and 9, those are bail matters, my lord. We are required to file an affidavit, my lord.
Yeah,
But there was some defect in
you're making submission in this.
mention, my lord. Number 8 and 9. It's a hearing matter.
You should have been fast. Huh? She has already called out item number 1.
Sorry.
So, see, I'm also confused, is it? The one thing that is required from all counsel, all concerned, is to bring clarity to the situation. Yes. Otherwise, I might pass it to confusing idea. That's beside the point. Tell me.
Number 8 and 9 hearing items, my lord.
Yes, so
But we are required to file affidavit. In fact,
what is this? These are
the bail matters, my lord. NIA.
Oh, bail.
This is appeal under
Bail
the
appeal, my
NIA
lord,
Act.
under NIA Act.
21, section 21.
Yes, 21 subsection 4, my lord.
So, my lord, there was some defect in the affidavit, so the registry didn't accept it yesterday, my lord. So, my lord, we will rectify it. We will try to rectify it and file it today, my lord.
You are appearing in both cases, Mr. Yugin?
No, no, my lord. I am only in the number 8, my lord.
And 9, Mr. Thapa. He's not here.
Thapa is there. So, my lord, if the matter comes Friday, my lord, by tomorrow we will try to rectify it.
After 1 week. Dr. N. Musical at DSGI has submitted that due to some clerical, due to some mistake, the affidavit could not be filed today. It is prayed that some more time may be allowed for the said affidavit to be filed. Pray allowed. This is matter. Today is
28.
Today is 28.
This is matter on 5th.
3 weeks, my lord.
5th.
5th.
That'll be next week, isn't it?
Next week, 5th, my lord.
5th is Thursday.
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 Yes, Thursday.
My lord. Obliged.
Deputy.
Supplementary list item number 1.
May it please your lordships. This is a review application, my lord, from the judgment dated 13/6/2024, my lord, in read appeal number 18 of 24, my lord. Now, my lord, there is a delay of, my lord,
Notice issue?
my lord, only 35 days, your lordships.
No, have you issued notice on the other
Only
side?
35 days, my lord. She's here. It can be condoned, your. Now,
Not
my lord,
without, not without the other side's presence.
she's
May I
a
please, your lordship, I'm accepting notice on behalf of the
Or
state.
my lord, what I want to submit your lordships, my lord, only 35 days since she is
37.
appearing. My lord, what matters here is there genuine ground for review, my lord. There is a very genuine ground for review.
delay control. What Mr. Sen and counsel for the review petitioner, who has submitted that review petition has been filed. However, review petition has been filed as regard the order, judgment order dated
Order dated, my lord, 13/6/2024.
13/6/2024, passed in WA number 18 of 2024, passed by this court in WA number 18 of 2024. However, in preferring the said review petition, a delay of 37 days has occurred, which condonation is prayed for. On sufficient grounds being shown, this court is inclined to allow this petition. Accordingly, Shuaikatu I, Ms. S. Shaji Leonard J has entered appearance on behalf of the respondents. As such, no formal notice is required to be issued upon such respondents. To last line of delay accordingly condoned. Petition disposed of. Registry is directed to diarize the main review petition, matter to come up after 1 week for admission.
If I can pray, your lordship, if this matter can be posted on next week, your lordship, Monday or Tuesday.
So I said 1 week.
1 week.
1 week means within 1 week. So if you want a specific date, fine.
No, it is already, your lordship. Only other thing, my lord, there is some, my lord, correction required with regard to certain dates. Though, my lord, I am referring only to the records, nothing beyond the records. But in the review petition, my lord, some dates are not correctly mentioned, my lord. If those I can correct.
What do we do then? Fine. See, the review petition has not yet been registered.
Okay.
Direction has been given to the registry.
It's not yet registered.
So you go before the registry and make the necessary correction.
But how, my lord, this my lord, operating and other things will not do.
Sir, Sir has further submitted that in the main review petition, some
review petition,
some clerical mistake has occurred.
With regard to date only.
Whatever, as for which correction is required to be made and prayed for accordingly. On prayer made, the petitioner, review petitioner is allowed to make the necessary correction before the registry.
Wednesday, next Wednesday. Lordship only thinks, since your Lordship, if it can be posted, my lord, specifically next Wednesday, it will be 1 week, my lord. Otherwise, it may not come.
This is matter of 4th.
8 September, next Wednesday. That is 4th, my lord.
I've already said this is matter on 4th.
Obliged, my lord.
On daily list, item number 1.
Yes. Yes, tell me.
Please, Your Lordships. Your Lordships, these are appeals passed, filed challenging the single judge's order dated 28/3/23. All 6 appeals are against a common judgment and order, Your Lordship.
My lord, as per the order dated 3rd June, my lord, the state is required to file some affidavits.
I think some status report
We
on.
have filed, Your Lordship.
You have filed?
We have filed that.
We have not received.
We have filed this on 21st of June 2024, Your Lordship.
Oh, yes. Why was it required?
Because the appellants had mentioned that the 31 temporary
My lord,
all
what
of
had
them
happened
are
in
not
this?
given the same treatment, that there has been discrimination and all that. So we just wanted to bring on record that there has not been any discrimination among the temporary employees.
So all the 31 have also been appointed
No,
on.
my
a
lord, what has
temporary
happened in
basis?
this case, my lord? There were altogether 31 ad hoc appointees, my lord, in 4th grade, my lord. But certainly for no reason, my lord, the salary of all the 31 were, my lord, stopped. And they had been running from post to pillar, my lord. Now, my lord, after 6-7 months, my lord, because some of them were, my lord, under unfathomable, my lord, financial difficulty. So 9 of them approached this honorable court by way of writ petition for a direction for releasing their salaries, my lord. That was given, my lord. Surprisingly, what had happened, my lord, in compliance with the order, my lord, for disbursement of the salary, the same was done. But another order was passed, my lord, that their service won't be
So
extended.
your case is
My case
your
is
case
that-
is a question of victimization.
Victimization, my lord. And that apart, my lord, I have been replaced by another ad hoc appointees, my lord. Those are my cases. Now the stand of the state was that, my lord, no, not only the 9 who approached this honorable court, but also the 31, their service has not been extended, my lord. So that was supposed to be brought on record by way of affidavit, my lord.
Your Lordship, they were all temporary employees who had not been regularized. They may have been working for some length of time, but since their service was not regularized, and then there was some disruption in their salary, and by the order of this honorable court, Your Lordship, in a case filed in the year 2018, Your Lordship, at the motion stage only, the court had directed that the government that you should release their salary. So accordingly, salaries were directed to be released by the Director of Health Services, Your Lordship, and in that letter, he gave a general order saying that henceforth no temporary appointments should be made without the approval of the competent authority. It was not just a case of these people who had approached the court for their salary, because so many temporary appointments were being made against the state government's different notifications, Your Lordship, and that too at the district level, not by the competent authority. Which is why, Your Lordship, they have come with against that letter also saying that we are victimizing them because they had approached the court. But that is not the case, Your Lordship. Your Lordship may hear us, Your Lordship, at length, and then we can try to satisfy.
We may also be looking at the issue of a level playing field.
My lord,
yes.
So we'll see how it,
it may be posted for hearing, my lord.
Pans out.
Yes, Your Lordship.
So what is?
They're all temporary appointees who have never been regularized.
You're looking at that? When you compile these, I think you better do it carefully. I don't know whether it's the office or in my brother's copy. Page 4 comes, then next is page 6.
Which? Sir?
Your affidavit.
My affidavit.
But anyway, we have.
My lord, I have not received the copy of the affidavit, my lord.
Difference.
Okay, we'll just,
it was just a, wrong, pagination. Not pagination.
Not pagination. Keep the
wrong insertion of the
insertion correct, Your Lordship.
We have not received the copy of the affidavit, my lord.
We have given you.
This 31 persons, are they respondents in this case?
No, Your Lordship. They are not parties in this case, Your Lordship.
Then his grievance is against whom?
His grievance is against the state.
And that is all right, but then he says that some ad hoc employee has been appointed by replacing.
No, those people have already been removed, and in their place, the district selection committee recommended candidates have already been put in place.
They have been made parties here.
My lord, service is complete, my lord.
Those people who have made parties are not no longer in service.
Will this matter for hearing?
My lord.
Those people who have made parties, they are no longer.
Because their contention is that they are also temporary. So we have now replaced with the properly, regularly appointed.
Oh, is that so?
No, my lord.
That is there. Huh?
Well, my lord.
See, Mr. Guru, let us be clear. When you file this appeal, you have pleaded those persons who have been appointed in your place.
My lord, yes.
On ad hoc basis.
My lord.
Temporary, Your Lordship.
Yes, temporary. Yes. Temporary ad hoc basis, whatever. Yes. Now, you say that those have also been removed and...
No, they had not. Actually, my friend is saying that these people, the appellants, have been replaced by ad hoc temporary employees, Your Lordship, and those people have been made parties. But those temporary employees, Your Lordship, were not put in place of the appellants. It was after 2-3 years, due to the exigencies of the circumstances, they were kept for the time being till the district selection committee recommends a regular candidate, Your Lordship.
That may be noted, my lord.
Yes,
that
Your
itself
Lordship.
is a discrimination, my lord.
Mr. Guru, we'll have to be very clear.
My lord.
The appointment is against a post, or the appointment is against a person who have vacated the post. If you have been made to vacate the post, and the appointment is made in your stead,
same post,
then, but that has to be clear.
My lord.
Otherwise, if you see what Ms. Yangi is saying, if appointment has been made to a number of vacancies, not necessarily,
my post,
as far as you are concerned, not necessarily in your post, then that also has to be considered.
My lord will hear us.
Take your lordship to every point, Your Lordship.
Parties have submitted that the pleadings in this matter is complete and the same may be posted for hearing. Accordingly, this is matter for hearing. How long?
After 2 weeks would be better, Your Lordship.
2 weeks.
Deeply obliged.
That is 1 to
6, Your Lordship.
6.
Item number 7.
Deeply obliged.
My lord, in this case, I pray for 2 weeks' time, my lord, to file our objection, my lord.
My lord, I have serious objection, my lord, in this matter. This is an appeal, my lord. One thing, my lord, question of filing any objection or my lord affidavit
That
doesn't
was
matter.
already allowed, my lord, by the last.
No, no, my lord. What is my problem, your lordships? I have preferred an appeal, and Weybridge was settled with me. This was supposed to continue till 25 September. I mean September 2025, my lord. So somehow, my lord, learned single judge, my lord, I have challenged. This has been cut short. I have challenges before the learned single judge. For some reason or how, my lords declined to interfere. I am before this honourable court. Now this Weybridge has been taken over. Now, my lord, hardly I have less than one year left. So unless, my lord, this matter is heard, at least, your lordship, at the earliest, but the very purpose of filing this appeal will be frustrated.
My lord, it was already allowed, my lord.
But the allowed doesn't mean it will go on taking time like this.
Another, my lord, only.
No, lordship,
2
my lord,
weeks,
may I pray, your lordship? Lordship post it for hearing. In the meantime, my lord, if they want to file it, let them file. Otherwise, we'll proceed, my lord. Lordship will proceed.
You see, I also fail to understand, you see, as far as
I don't know.
writ appeals are concerned, or appeal are concerned, why?
There is some.
I got what you every document. If you say that a document I have not annexed, my lord, before the single judge, I understand. Everything I have annexed, including the, my lord, written argument submission made before the
It
court.
is required, my lord. That is why.
How it is required, your lordship? Only
My
because
lord,
the permission has been
That is
given.
not the concern of the.
Should be my
writ
concern. It's
appellant,
my.
my lord.
I am the appellant. My
Whether
lord.
it
Why
is
I should
required
not?
or not,
Why
my
it should be delayed like
It
this?
is for us, my lord,
This
to
is only
decide
your
whether we
pretext
have to
delaying
file
the
or not, my
matter.
lord.
Why it should not be my concern?
And why would this court go beyond the records?
Exactly, my lord.
My lord, that is, my lord, we need to at least file that objection, my lord, and to bring on record some.
But let him show that I have not annexed anything.
Objection means at the time of hearing you can object and cite some authorities and so on and
I
so forth.
pray for only 2 weeks' time, my lord. I will file
Lordship
it
will
within
post
that
it for
time.
hearing, my lord.
Yes,
In the meantime,
as
he
Mr.
files
said,
already. He
we-
doesn't
we
file, my
proceed.
lordship will proceed.
No issue.
Mr. Ensign Leonard J has submitted that the objection which was allowed by this court to be filed could not be done so today and has sought for accommodation in this regard. Mr. Per contra, Mr. S. N. Leonard, counsel appearing for the appellant has objected to the same on the ground that time and again such similar prayer have been made and the hearing of the matter is thus delayed to the prejudice of the appellant. The court, on consideration of the submission made, would allow the respondent to file the objection if any. However, as prayed for by the learned counsel for the appellant, this matter will now be posted for hearing. The respondent, in the meantime, are allowed to file said objection. This is matter to 2 weeks.
All right.
Item number 8.
May please.
Well, in this matter, your lordship just directed us to file the written argument. I think on the last occasion, my learned friend had also informed this lordship that we are filing it.
Yes,
The
so-
difficulty with this written argument is, well, when it came before me, it would rather, well, be more confusing than sorting out whatever was the issue before your lordships. Something has been prepared by them, well, but it does not really go into the issues that we had argued before your lordships in essence. I'm praying your lordships kindly allow me till Monday, Malaz. We'll just ensure that correction. We'll change it to a bulleted point, Malaz, if that.
Whatever, you see, the only, I think the only issue to be discussed, to be decided
miscellaneous
here
application filed by my friend,
is the status of the, the petitioner or the
Lordship.
applicant, whoever he is, as far as, his status as a, substituted party,
Lordship.
or a person who is seeking intervention.
Lordship.
So those are the,
What has come as my lords is that the entire story has been narrated, but missing out on the substance of what has been argued before your lordships.
please do
Kindly
it
permit me till Monday.
as soon as possible.
My lords, we'll ensure by Monday it is there with the lordships.
Because I believe this matter will again, not end here. First, we have to decide on that
That
point.
issue.
Then, if that is decided, then we go again to the merits of the.
As a matter of fact, your lordships would recollect, my lords, I had submitted that some remedy would be open to the respondents once the matter reaches
Yes,
the appropriate
we could
authority.
have-
Because the challenge before your lordships is with the issue of law.
Exactly.
Be that as
Yeah,
it may, my lords,
since it's a revision petition, then it's only issue of
your lordships will
jurisdiction.
confine only to those relevant issues. But since they're insistent, my lords, we'll have this corrected to assist you.
Mr. K. Paul, Leonard, Senior Counsel, has submitted that the written argument on behalf of the
My lords, we would be the respondent in the IA, my lords.
respondent,
In the miss case, my lords, sorry.
respondent oblique petitioner. How come miss case mo ni? Kung to? could not be filed today on the ground that though the same has been prepared, some correction is required, which accommodation is sought for in this regard. Remit seems allowed. This is matter to 1 week.
I'm obliged.
Good.